Okay. Very good evening, everyone. So, first of all, I welcome each one of you to my class on the Indian Penal Code 1860. And today we are going to discuss one of the most important topic, that is punishments. Basically, chapter number 3, starting from section 53 till section number 75. So let's start this class with my brief introduction first. My name is Sandeep Khatri. These are my areas of specialization, as you can see on the screen. Here is the link of my profile of Unacademy. So make sure you follow that to get all the updates about my special classes and my plus courses. Here is the link of my Telegram channel where you can ask your questions in relation to judicial preparation. At last, I have shared my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive. If you are not clear with anything, feel free to ask questions in the comments. Students, before starting this class, I have an important announcement to make that I have already covered all the 9 special laws in this special law series. And all these classes has taken place in my special class. So that means it is completely free of cost. And if you are facing any issues in relation to any of these special law, whether when it comes to the explanations of the provisions or in the MCQs, I have covered the both. So you can refer my Unacademy profile for that. Now coming to the topic of this class, that is punishments. So what all we are going to cover today. So first I'll give you the basic introduction of this topic. After introduction, we are going to discuss some important provisions. So basically some important sections like section number 53, what is the role of section number 57, 63, 65, 67, and so on. And then we are going to discuss the concept of solitary confinement as well. That is section number 73 and 74. So we are going to discuss the important provisions. And in between only, I'll discuss the landmark judgments in relation to that as well. So this is what we all are going to do today. Okay. Before starting the class, if you have anything in your mind, if you do have any questions in relation to this topic or this subject, you are free to send your questions in the comments and I'll answer accordingly. Okay. Now let's start this topic with the basic introduction first. Now what is punishments? Students, if you go by the meaning of the term IPC, so IPC is nothing but it states offenses and their punishments. So the concept is basically in the meaning of the subject only. You know, the whole subject of IPC can be broadly divided into 2 parts. One is offenses, that what all are the offenses, which are basically offenses against body, offenses against, for example, offenses against body, offenses against property, offenses relating to documents, offenses related to marriage, offenses related to elections, offenses relating to religion, and so on. And the second part here is the punishment. So what kind of punishments we can give under IPC? So when you see what kind of punishment, then we do have one important section in relation to this, and that is section number 53. That is basically talking about 5 kinds of punishments. Now what are those 5 kinds of punishments? So the number 1 is basically the death penalty, which is also known as capital punishment, जिसे हम फांसी की सजा कहते हैं. और ये किस तरीके से दी जाती है स्टूडेंट्स? दैट इज हैंग टिल डेथ. फांसी की सजा दी जाती है. फॉर एग्जाम्पल, व्हेन इट कम्स टू कंट्रीज लाइक यूएस, दे डू हैव अ कॉन्सेप्ट ऑफ इलेक्ट्रिक चेयर. ओके. So now coming to this whole debate whether death penalty should be favored or you should be against the concept of death penalty. There are points in support, there are points in against as well. But as far as Indian law is concerned, as far as the Indian Penal Code is concerned, students, death penalty in India is something which is not prohibited. Now, the second question is, in what kind of cases death penalty is awarded? So, we do have a doctrine in relation to that, and that is known as rarest of rare case. Now, what is this rarest of rare case? Even in this concept, there is no exhaustive list that, okay, these 4 or 5 offenses comes under the category of rarest of the rare case. But whenever an offense has committed in such a manner which is rarest of the rare, then we left with no other option but to award death penalty. Now let's take some examples in that. For example, parliament attack, the act of attack of parliament, that is in the case of Afzal Guru, that is something which is rarest of the rare. Or you can take example of rape that has taken place, that is something which is rarest of the rare. Now you can take example of the Mumbai attacks, the Ajmal Kasab case, that is also something which is again rarest of the rare. So basically, when an offense, when you have crossed all the limits, and then we left with no other option but to award death penalty. When it comes to this rarest of the rare theory, you can go through with this landmark judgment of Bachchan Singh. Bachchan Singh is a landmark judgment which gives that death is not, capital punishment is not something which is unconstitutional under Article 21. Okay, because when you read Article 21, which gives you right to life, that has also some exceptions. And one of the exceptions of Article 21 is your death penalty. So if that is something which is prescribed by the law, then you cannot exercise your right to life. So another thing is, when it comes to the concept of death penalty, there are usually we demand this kind of punishment or capital punishment, even in the cases of, this whole question comes into the debate at the time of rapes also, that people demand that there should be capital punishment for any kind of rape. And yes, there are people who support this point of view, there are again people who don't like this point of view. And the basic conclusion of both the discussions are that even in the countries where there is capital punishment in rape, they do still, uh, struggling still with those kind of offenses. So basically, what kind of offense, what kind of punishment should be there, that also gives rise to a new question, that what are the theories of punishment. So there are different theories of punishment. For example, there is preventive theory, there is retributive theory, there is a deterrent theory, there is compensatory theory, then there is the last one is your multiple approach theory. So when you look at section 53, it is not something which is only following deterrent theory. So deterrent theory is basically when you give the wrongdoer the most harsh punishment he can think of, or you basically make example out of that person. So like capital punishment is one of the example of deterrent theory. Then we do have preventive theory as well. For example, the police usually arrest to prevent the offense. So that is your preventive theory. Or retributive theory, which is basically if someone has broken an arm of some person, then the another person will also break the arm of another person, which is kind of your revenge. But there is a strong criticism from that an eye for an eye will make the whole world blind. So there are different theories of punishment, and there is no single theory that has been followed in IPC. So I will take one more example on this. Remember the concept of victim compensation scheme. So that is basically from your compensative theory. So my bottom line, why I have discussed all these theories, is that justice could never be based on some single theory. And that is why we do have a concept of multiple approach theory, which usually IPC follows in all these 5 punishments. Okay. Now, coming forward, after death penalty, then there is the second punishment, that is your life imprisonment. Now, coming to the meaning of this, what is life imprisonment? If I can tell you very straight and in a very simple manner, the meaning of life imprisonment is basically till death. It's as simple as that. I'm repeating myself, life imprisonment means till death. Period. That's it. There is no such concept called 14 years of 20 years or 25 years or whatsoever. Life imprisonment means life till death. Now, how much it can be, that again depends individual to individual, and we can never know. A person may survive for the next 2 years, or 20 years, or some 50 years. That is something which is not our problem. The thing is, life imprisonment means till death. Now, coming to the second question in relation to this topic, then why such confusion was there that it is 20 years or it is 14 years? Now, let me tell you, students, the thing is, when you read the concept of life imprisonment, it is usually read with section 57. Now, coming to the role of section 57, okay, let me make an example here. Okay. Now, listen carefully. Students, if I tell you that there is 10 years of imprisonment, and I want you to tell me one half of it. Basically, you need to half that imprisonment. So that's simple mathematics. You will tell me, but what about one half of life imprisonment? Now, life imprisonment, I just told you, it means till death. Then, in that scenario, how can you do that? So, for this fraction, we will presume. So, in that case, there comes the role of section 57. And section 57 says, whenever you are facing this kind of a question, that you need to tell me the one half of life imprisonment. So basically, we because of obvious reasons, we cannot tell for how many years this particular person is going to live. Okay. So in that case, section 57 say, now you just presume that the life imprisonment is of 20 years, and then you can tell me what is the half of 20 years, that is the 10 years. This is the rule of section 57. But section 57 doesn't state that life imprisonment means 20 years, life imprisonment means till death. The only role of section 57 is to do the fraction. If you need to calculate life imprisonment, if you need to make one half of life imprisonment, then you will apply the concept of section 57. Now, there can be one more question in your mind in relation to that, and that may be, sir, when will we face this kind of question? So, the answer to that question is, for example, section 511, which is basically the punishment for attempt. Okay, so suppose if someone has committed an offense, so basically, if someone has committed attempt of an offense whose punishment is life imprisonment, now you make half of it. So you will apply the concept of 57, and the answer is going to be 10 years. So I hope now it's clear to you. And still, if you have any doubts, feel free to ask your questions in the comments. Okay. So that was your life imprisonment. Now coming to the third type of punishment, that is your simple imprisonment or rigorous imprisonment. See, they both are the kinds of imprisonment. First thing, both are kinds of imprisonment. The major difference between simple and rigorous is, in case of simple, there is no such hard physical work involved. So, for example, if someone is working in a room under a fan, if someone is making a chair, or if someone is working in a kitchen, then that will be considered as a punishment of simple imprisonment. But when it comes to rigorous imprisonment, that involves higher degree of physical work. So that is the major difference between these two concepts. Now coming to the fourth kind, that is usually your forfeiture of property, and the last one, your fifth one, is basically fine. Now forfeiture of property, that is that a court has power to take possession of the property, to take the control of the property. And similarly, fine is something that is in relation to your money. Okay. Now there are two more kinds of punishments which you should know at this stage of time. Okay. The very first one is transportation for life. Now, what is this transportation for life? You must have heard those story Kale Pani Ki Saza. Okay, so usually we send the person to the Andaman and Nicobar. Okay, and there used to be the punishment of transportation for life, that the person will not return to that place again. Okay, now coming to the second punishment which you should know about this is, that is the penal servitude. Now, what is penal servitude? So, penal servitude is basically the higher degree of rigorous imprisonment. So, the status of these two punishments is such that this transportation for life has been now substituted. Mind my word, substituted. And this is substituted with imprisonment for life. And if you want to go in detail, you can read section 53 clause A. Section 53A, you can read that. Now coming to the status of penal servitude. This is something which is omitted. So originally there were 6 punishments. The 2 were this, and the rest 3 were fine, forfeiture of property, simple imprisonment, rigorous imprisonment, transportation for life, penal servitude, and death penalty. These were the originally 6 punishments under section 53. But as of now, the current status is that there are only 5 kinds of punishments. And what are those 5? The very first one, which I have discussed just, the death penalty, which is capital punishment. The second one is imprisonment for life. The third one is simple imprisonment or rigorous imprisonment. The fourth one is forfeiture of property, and the fifth one is basically the fine. So these are the 5 which are the final one. Okay. Now, if you have any questions from the punishment part, okay, if you have any questions from the punishment part, section 53, or the theories of punishment, you may ask. Yes, Ayush, cellular jail was the part of your transportation for life. Still, there are jails available in Andaman and Nicobar. Okay. I guess those are available for now tourism purposes. They are no more in use as of now, because later on we recognized the prisoners' rights as well. Okay, like they do have the rights of proper clothing, they do have the right to food and shelter. Okay, so that was the reason. Now coming to the last punishment, that is of fine. I'll go into the detail of that. Now let's discuss this one, that is fine. Now usually you will find out that the amount of fine has not been mentioned. Usually in most of the sections you will find where the punishment has been written, It usually says imprisonment of either description, which may extend to 3 years, or fine, or both. Now they have just used the word fine, but not the amount. And in that case, there comes the rule of section number 63. Then what can be the amount of that fine? So the concept says that this amount of fine can be unlimited, which means there is no such limit. There can be fine of 100 rupees, 1000 rupees, 1 lakh, or 1 crore. That is something which is unlimited. But at the same time, this unlimited you need to read with, but not excessive. And this not excessive here means, like in Hindi we use this word anab shanab. That is, you are not excessive. So unlimited but not excessive as per to section number 63. So that is the concept, which is something in relation to fine. Now coming to one more thing in relation to fine. Correct answer, Ayush, unlimited but reasonable. Completely correct. Now coming to, listen this carefully. When you say that there is punishment of fine, you can divide this whole concept into two parts. Either there is fine only, which means the person who has committed an offense, for that the punishment is fine only, or there is some years of imprisonment or fine or both. So basically, what I have done is I have divided the whole concept of fine into two parts. Either there is going to be punishment of fine only, that you, whatever your offense you have committed, there cannot be any imprisonment in that case. Or in the second part, there can be imprisonment or fine or both. Right? Now coming forward, what if there is punishment of fine only? Let's take an example, 1000 rupees maximum fine that can be applied for one particular offense. And this person has not paid that fine. Now what will you do? Now what this imprisonment? So just wait for this one. Now coming to this one, if there is imprisonment or fine or both, but the fine that has been given is 1000 rupees. In that case, if this 1000 rupees has not been paid, then he again needs to go to imprisonment. Now coming to the conclusion part. In both these cases, which concept you are going to follow? Answer to this one. For this, you need to follow the concept of 1/4, which means whatever imprisonment is mentioned on this part, for example, there is 2 years of imprisonment. So 1/4 of 2 years is 6 months. So maximum you send someone for 6 months only, not more than that. Now coming to this part, there is no such imprisonment available here. So for that, you need to follow a specific chart. I'm giving you that specific chart. And that chart is basically related to the fine. So this is the imprisonment the person will get if the fine is such. If the fine is below 50, the person will get imprisonment of maximum 2 months. If the fine is from 51 to 100, the maximum imprisonment can be 4 months. And if the fine is above 100, then maximum can be of 6 months. Okay, so this is the chart you need to follow. Ayush, oh, I hope the video is running fine. Okay. Now coming to the okay, let me conclude this one again. So basically, from this chart, what I really want to convey is that the whole concept of fine can be divided into two parts. Either there are going to be provisions where the punishment is fine only, or there are going to be provisions like imprisonment of either description, which may extend to 2 years, or fine, or both. In both the cases, if the convicted person got the punishment of, if got the sentence of 1,000 rupees of fine, in this case also he got fine of 1,000 rupees, but this person is not submitting the fine, then what you can do, then we will give him the imprisonment. Now in this particular case, for how much time he is going to get the imprisonment. So the fine was above, fine was 1,000 rupees, so that was something which was above 100, so we will give him maximum imprisonment of 6 months. First is this. Now coming to this one, if there is imprisonment or fine or both, then the maximum imprisonment cannot give him more than 1/4 of 2 years. Now, what is 1/4 of 2 years? That is of 6 months. Okay. I hope everyone is clear with this chart. If you still have any questions, Ayush or anyone else, you may ask. What is the upper limit above 100? Above 100, if there is a fine above 100, which is 101 till any infinity number, then the maximum imprisonment we can give him 6 months only, not more than that. Okay, Ayush? So it's 6 months for above 100. Okay. Now coming to the last topic of this class, that is of solitary confinement. So solitary confinement, who usually give? Solitary confinement is given by the court. What is the maximum period you can give in solitary confinement? That is of 3 months. So there is again a chart which you can follow for solitary confinement, and that is of, I'll just share the chart with you. Solitary confinement, imprisonment. So if someone comes into jail for 6 months, the solitary confinement he can be given maximum up to 1 month only. If someone comes for 1 year, 2 months, and if someone is above exceeding 1 year, then maximum can be the 3 months. So what is solitary confinement? Solitary confinement is again a kind of, you can say, imprisonment, but in this you will not share your room with anyone else. Okay, you are going to be alone in that, and this is something which is going to have some, mental issues to the prisoner as well. Okay. So this is the concept of your section number 73. Now you will read the concept of section 73 with section number 74, which says, if you are coming more than 3 months, or you are going to come into the jail less than 3 months. If you are going to come in the jail for less than 3 months of imprisonment, in that case, You can give him maximum 14 days at a time. This is something which is the maximum time period of solitary confinement. And minimum break of same days. Okay, if you are giving someone 14 days of solitary confinement, then you have to minimum give him the break of 14 days. If someone has come to the uh, imprisonment for more than 3 months, then the maximum solitary confinement can be of only 7 days, and with minimum break of 7 days. So that's the concept of your solitary confinement. So coming to the conclusion of this class now. So this is the link of my profile, students. Let's wrap up the session. This is the link of my Telegram channel. If you do have any questions, any queries, you may forward your question on my Telegram channel. This is my code Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So let's crack PCSJ with Unacademy. These are some upcoming batches, students. Regular linking course 2023 already started from January 26. Rapid revision for Uttarakhand Judiciary already started. This is going to be start from Feb 1st. Rapid revision for West Bengal Judiciary already started from January 23. These are the judiciary notes which are going to be launched on 30th of January. Okay, these are the key features. Important announcement, students. You can celebrate your Republic Day and you can get 20% off on all your judicial subscription. And this is something which is not, this is now valid till January 30. Okay. Price hike is coming soon, which is from 1st of Feb. These are two important announcements for those who are appearing for UP Judiciary Prelims Mock Test Series. Okay, Unacademy has already launched. So there are going to be 3 tests on 3rd Feb, 5th Feb and 7th Feb. This is completely free of cost if you are a plus or iconic student of Unacademy. And a very minimum cost if even you are a special law class student. On the same pattern, there is a Chhattisgarh Judiciary Prelims Mock Test Series also, and you can get 5 tests here on 6th Feb, 9th Feb, 12th Feb, 15th Feb and 18th Feb. That's it from my end. See you in my next class. Till then, yes, it's time to say peace.